Don't mess with me. I'm making it all the way to the year 3000.
The eternal Sith Lord, Mickey
Yes,
Mouse.
he is my master.
Okay, do that voice and cross it with Mickey.
You don't know the power of the dark side. Because I'm Mickey Mouse. I find your lack of faith rather disturbing. I am your master, Vader. Yes.
Wait.
Oh,
no. I had to cut the mic on that one.
That's why he never got to be emperor.
Welcome to 7Robots.
Fantastically Terrible Podcast. Episode 21, Copyright Basics for Artists and Writers. So you want to create something, maybe a comic, write a book or a song, create a star base that can destroy planets. Great, let's do it.
But wait, how do you begin?
How?
To copyright or not to copyright?
Which one is it?
Well, we've been through this process, so we want to give you some real hands-on practical information that we hope provides you with a good start for your intellectual property.
We emphasize that.
Yeah, not someone else's. We'll cover the basics, mainly of U.S. copyright law, and review why it's a good idea to register your work. At least we think so.
All right, I hear a lot of stuff out there where people confuse copyright and trademark.
All the time.
All the time. It drives me crazy. So first of all,
So set us straight, Miguel.
we're going to get the differences, okay? So copyright protects the original artistic and literary works. In other words, your creative content. Trademark is for a brand for goods and services. It is not required, but it enhances your rights. In other words, Nike, that kind of stuff, like a brand name.
Exactly, brand. Your mark.
Brand.
They often call it a mark as well.
A mark. And sometimes people confuse trademark and copyright, and it drives me crazy.
You can trademark a name. Mm-hmm. You can also trademark the design of a logo.
And sometimes even colors now, too, unfortunately.
You try to associate colors with your brand,
Right.
Which happens. There's different cases where
And
they've
there
done
is
that.
a dark side.
Well, they
of
tried
that
to
force.
trademark the rounded corners on an iPhone, things that make your product distinctive. It doesn't always work, but
Right. They try.
the very basic is your company name and also the logo, the artwork that you designed to represent your company.
Which leaves us with one last one.
Yes.
And I hope to God I never see this confused with the other two.
People normally don't confuse this.
I hope not. Patent. That protects your inventions.
That's right.
So if you're creating not a comic or a book or literary work, but you're actually creating something like an invention, like the telephone.
They also give you patent on software as well, on programming.
Yes.
But it has to be very distinct and new and original, and you have to go through a very long process.
Right. And you need a lawyer for that now.
You definitely need a lawyer for that. You can do it on your own, actually, but it's very recommended to have a lawyer. But for our conversation today, we're going to focus on copyright.
That's right.
Miguel, is your work automatically copyrighted?
Yes. All original works of authorship, not ideas, that are created for the first time are protected.
You might ask yourself, then why would I need a copyright
Why?
if everything I create is automatically copywritten?
Yes.
And the answer is more the courts. If things don't go well, if someone does steal your song or your book or your comic, it gives you proof that you had it. It marks the year, the day, you get a number, and it's easier to prove in court,
Right.
if you ever need to, that this indeed was yours and you did it before the other person and you can prove it. Where's my proof? Bang! My copyright certification.
Correct.
So it's not essential, but if for some reason things don't go well,
Right.
it's easier to prove it.
Now, what is not protected by copyright?
I'm glad you asked, Miguel.
Yes.
Copyright does not protect facts, ideas, systems, or methods of operation. You cannot copyright the sun. You cannot copyright 1 plus 1 equals 2.
I will copyright it.
Again, your idea, you can't
Right.
copyright. Okay. When is my work protected?
When is it?
Back at you.
Oh, okay. Well, your work is under copyright protection the moment it is created and fixed in a tangible form that is perceptible either directly or with the aid of a machine or a device.
That's very technical.
Yes, I should have done that in that voice. This means that whether you wrote it on a computer or with pen and ink, it is protected.
Okay. Because they must get so many people saying, I have this great idea.
Yeah. I
We
hear
need
that a
more
lot.
than that.
Having it in your head's not good enough. So, have you heard about the poor man's copyright?
I have.
Okay, so do you know what it is?
Don't do it. The poor man's copyright is when you used to mail your work back to yourself.
Yes.
And the logic, I think, is solid, which is if it goes through the U.S. Postal Service, if I create a comic, if I write a book, if I write a song, I put it in the mail, I pay for it, I mail it to myself and receive it, there's proof of that, right? There's a stamp, it's official, it's a government office. However, it's not considered a substitute for actual registration.
Can I make an admission? Mm-hmm. I used to do that when I was very, very young.
Oh, because a lot of people talk about just mail it to yourself.
Right. I used to do that.
And that's why it is a solid logic.
Yeah.
And to show that, look, I never opened it and it's here and it's from the U.S. Postal Service.
Right.
So I think it could be useful, but it's not copyright protection.
I guess it's better than nothing.
I suppose.
If you kind of like show up and go, they took my idea. I got it in my sketchbook. Yeah, from what year? Okay, but I got this envelope. So, I can kind of see the logic. Yeah, but no, don't do that. So, how much does it cost to register with the U.S. Copyright Office?
After going to the copyright.gov website, all of the links for this episode, as always, will be available on the blog post for this episode on our website.
Okay.
Fees are, of course, always changing, but I just checked today, and they have numbers from 2020.
Okay.
You can do an online registration of one basic claim in an original work of authorship, $45 for an electronic filing, and $125 for a paper filing. And there's a few here. If you go to the page, you see all the different options you have. They have for photographs, they have for artwork. And another one that I found interesting, especially if you create comics, is a registration for a claim in a group of serials, which is $35 for an electronic filing and $70 for a paper filing. And I encourage you to go and take a look because there might be different categories that apply to you depending on your intellectual property. Mm-hmm. Now, Miguel, why would someone register their work if copyright protection is automatic?
For legal reasons.
Yeah, we touched on this, but it's worth
registration is
emphasizing.
not needed for copyright protection. The purpose of it is to record a verifiable account of the date and content of the work in question, so that the event of a legal claim, or in the case of infringement or plagiarism, the copyright owner can produce a copy of the work from an official government source.
Bam! Signed, sealed, delivered.
That's right. So, can I sue someone if I'm not registered?
Nope.
That stinks.
A copyright owner cannot sue for infringement until the work is registered in the U.S. Copyright Office. You must register your work with the U.S. Copyright Office before or within 5 years of publication.
Wow.
To me, I find this problematic because if I am automatically protected, why do I need to register in order to sue for infringement?
Right.
This is one of those catch-22s I don't quite get. You don't have to, but if you need to go to court,
You're
you need
protected,
this.
but you're not protected.
Yes. So I don't quite get that.
Okay.
I mean, it's good that they give you 5 years. You don't have to do it immediately. But yeah, so this one, maybe you have to do a little bit more research if this should happen.
Interesting.
What is prima facie evidence?
I don't know, is it a pasta?
It sounds like a prima
Just
facie
kidding.
pasta. It's good for you.
Good for
Eat,
you.
Miguel,
Eat.
eat.
Copyright registration creates a prima facie evidence. This means that the copyright is valid and that the stated facts are true. To create a prima facie legal case,
Or prima
to
facie.
prima facie, in order to prove that you
I
are...
like your facie. You got an Facie.
To prove that you are the original owner, you must register your work with the U.S. Copyright Office before or within 5 years of its publication. So it's kind of reinforcing.
Yeah, what is it in law? So if you wanted to do some further evidence, that's what you would look up. You'd look up what is prima facie evidence, and how is that evidence applicable to my copyright if you want to do some more research.
So, how do I prove infringement?
I'll tell you.
Okay, tell me.
In order for a court to determine that a copyright in a work has been infringed upon, it must find that the infringing work is substantially similar to the copyrighted work, and the alleged infringer had access to the copyrighted work, meaning they actually saw it or heard it. So if you wrote something and it's in your house, in your sketchbook, written on your laptop, and then you see a movie that's exactly the same, you cannot sue for infringement. They never saw your work. It just happened by chance that they had the same idea.
You know, that kind of happens.
It does happen a lot. There's similar ideas, even similar designs, inventions. There's countless examples of people coming up with inventions at the same time.
Yeah.
So you need those two things in order to prove infringement. They have to be substantially similar, and the infringer or the accused infringer had to have access to see your work.
Okay.
There are no clear examples for deciding when substantial similarity exists between two works. Courts look for similarities in appearance, sound, words, format, layout, sequence, and other elements of the work. In other words, it's good to have a lawyer for this, someone who knows what to look for and what he's doing.
Someone who knows how to kind of wedge it.
Especially if you're trying to defend yourself.
Right.
Because it can be really hard.
Yeah.
How do you prove if someone saw your work or not? What if you have a Webtoon? What if you have music on SoundCloud? It's difficult.
What if you're going up against, like some...
If you're going against some money, that's super tough.
Yeah, that's super tough.
Is there a difference in damages awarded for registered or unregistered works? Dun, dun, dun.
Yes. It's easier to recover damages from copyright infringement if registration is timely. Timely registration occurs when the owner registers the work within 3 months after its publication or prior to commencement of the infringement. This creates a legal presumption of a valid copyright. If registered, the owner can recover up to $150,000 in statutory damages. If not registered, the owner can only recover compensation for actual damages and profits. Registration may be made at any time within the life of the copyright, unlike the law before 1978 when a work has been registered in unpublished form. It is not necessary to make another registration when the work becomes published, although the copyright owner may register the published edition if desired. Where in the world is Carmen Sandiego? Where in the world is Carmen Sandiego?
Okay, but you don't want to know where Carmen Sandiego is.
No, I don't.
What do you want to know?
I want to know where in the world is U.S. copyright accepted?
That's a good question. There's no such thing as international copyright that automatically protects a work throughout the world. You can't create something and you're protected all over the world. No.
Interesting.
However, there are a lot of different treaties.
Okay.
The Berne Convention is the one most cited because there's a lot of members in the Berne Convention. But I can put a link. There's many. It depends on what country you're from and what treaties that they have agreed to. There are more than 150 countries that have ratified a treaty intended to accomplish as many of the benefits of international copyright as possible. Generally, if a work is protected in the U.S., it is protected in most countries because the U.S. adheres to the Berne Convention, and that's administered by the World Intellectual Property Organization, or WIPO.
Well, thank you for answering that.
You're welcome. If I'm in Europe, can I copyright my work?
Not really.
Wah, wah.
When you create an original literary, scientific, and artistic work, such as poems, articles, films, songs, or sculptures, you're protected by copyright.
Yes.
Nobody apart from you has the right to make the work public or reproduce it.
In my research, which has not been too extensive, so definitely contact someone who knows what they're talking about.
Right.
It's like the U.S. Anything that you create is yours. The U.S. says the same thing, but then they say, but you could pay and it's good. And, it might help you out if you pay.
We'll give you a timestamp.
Exactly. So I thought maybe the European Union might have something like that as well, but I couldn't find anything. They just reinforced that any work originating in the EU, where the author of the work is a national of the European Union, or the work was first published in the European Union, is given the same copyright protection as granted in the Berne Convention. And as we mentioned, the Berne Convention, the full name is For the Protection of Literary and Artistic Work, is an international agreement governing copyright, which was first accepted in Bern, Switzerland in 1886. In EU countries, copyright protects your intellectual property until 70 years after your death, or 70 years after the death of the last surviving author in the case of a work of joint ownership. Any country outside the EU which has signed with the Berne Convention, their copyright lasts 50 years after the author's death instead of 70. Why you laugh?
I laugh because it's like, yeah, you're from the outside. We're going to clip you 20 years.
I guess the EU gave an extra 20 years. In terms of where you can register a copyright in the European Union, I'm not sure. You'll have to research that a little bit more. I do have lots of links I can give you for the EU and for the US. Everything I read sort of leads you back to you automatically have copyright protection.
Yeah.
So I'm not sure what you would use in Europe as proof. Of course, if you're published, that's proof, right?
Yeah,
if you
absolutely,
published,
yeah.
I'm in a magazine, I'm in a book, something like that.
Yeah,
But
you have your time.
but we're talking about little people.
That's little people. Yeah. What happens when copyright goes to the dark side?
Are you referring to the Mickey Mouse Act?
Yes, my master Mickey. I bow to the Sith Lord. That high-pitched mouse.
That's fantastic. I love it. Under the hood, it's Mickey.
Don't mess with me. I'll electrocute you. You don't know the power of the dark side.
In 1998, Congress extended copyright protections from works published between 1923 and 1977 by an additional 20 years. So instead of being 75 years, just they made it 95 years. Copyrighted creative works, whether they're books, movies, music, all of that, in this period of time, will now only enter the public domain after 95 years.
And only that period of time.
So the EU did a similar thing. The Copyright Term Extension Act, as it's known, also is referred to as the Sonny Bono Act or the Mickey Mouse Protection Act.
Mickey.
Because a lot of money and a lot of fancy lawyers were involved.
That's right.
With this.
A lot of pasta fazool.
The Sith Lord was involved.
Yes.
It essentially stopped works from entering the public domain that were set to expire. Therefore, Mickey Mouse specifically, who first appeared in 1928, will only enter the public domain in 2024 or even later.
Don't mess with me. I'm making it all the way to the year 3000.
The eternal Sith Lord, Mickey
Yes,
Mouse.
he is my master.
Okay, do that voice and cross it with Mickey.
You don't know the power of the dark side. Because I'm Mickey Mouse. I find your lack of faith rather disturbing.
God, no wonder Goofy was always nervous around him.
Mickey was a slave owner.
His best friend and his pet were both dogs.
Dogs. It's weird. It's weird. It's wrong. I am your master, Vader. Yes.
Wait, that doesn't sound... I had to cut the mic on that one.
That's why he never got to be emperor.
Yes, you are my master. I will do your bidding.
Good. Now go take Pluto out for a walk and clean up his poop.
Yes, your will shall be done. Now I know why they don't call me Master Vader.
The Fantastically Terrible Character or creature is Disney's Pluto. Did Disney purposefully muzzle this artistic genius? You be the judge. Pluto began his life in 1930 in the Chain Gang. As Walt Disney explained, we needed a bloodhound. Pluto got the part. Turned out so well, we used him twice. Yes, there were 2 bloodhounds in what is considered to be Pluto's first film, but Pluto was only paid for 1 part. This set the stage for how Pluto would be treated for the rest of his career at Walt Disney Studios. In the same year, he appeared in The Picnic. Here we get a glimpse of the real dog. His name was Rover, and he lived with Minnie, not Mickey. In 1931, Mickey used his power to take Pluto away from Minnie and forced the heartbroken Pooch to play his pet in The Moose Hunt. This power play forever damaged the relationship between Minnie and Mickey and explains why they never got legally married. Even though Walt tried to put Pluto under Mickey's foot, he fought to be given some dialogue and treated with respect. All he got was saying, "Kiss me," to Mickey. Even though audiences liked the gag, Walt was not pleased. Pluto was forever cast as a purely pantomime character. His dialogue and place in the pecking order was sealed. He was forced to play simple-minded gags as a mute.
As veteran animator Nick Nichols admitted, we've generally kept Pluto all dog. He doesn't speak, except for a breathy yeah, and a panting, raspy kind of laugh. Even when he displayed his exceptional acting ability in Playful Pluto in 1934, outclassing his co-star Mickey in an unforgettable sequence where he gets stuck in a sheet of flypaper. It marked one of the first times in animated history that a character appeared to be actually thinking. And what about Pluto's family? His wife, his puppies, he even had a brother. In 1937, Pluto's quintuplets starred Pluto's wife Fifi the Pekingese and their 5 little ones. It proved so popular that in 1942 he starred in Pluto Jr. with one of his pups. But the studio wouldn't allow people to see Pluto as a family man. They wanted him to be the silent, suffering bachelor. In 1942, Pluto even won an Oscar for Best Cartoon with his magnum opus, Len de Pas, beating fellow Disney actor and previous co-star Donald Duck. His bad temper and duck privilege were on full display in Truant Officer Donald. Even winning the Academy Award for Best Short Subject, a seminal achievement, was not enough. Pluto was still relegated to formulaic roles where he was never allowed to break out of his loyal, lovable, dim-witted persona. Here's to Pluto, the dog that proved he could have been more if given the chance.
That's it for today. 7Robots, Fantastically Terrible Podcast is by Miguel Guerra and Susie Diaz, and our theme song is by Susie.
You're cuckoo today. The best way to support our podcast is to leave a review on iTunes. It helps others to find us, and we can see your name and personally thank you live on the show. For anyone who's left a rating, we super appreciate it.
We do.
We just can't thank
Mickey
you.
does too.
We just can't use your name on the show because we can't see it. For more information on this episode, including links to all of the copyright information we've referenced and the Disney cartoons, please visit our website at www.7robots.com/podcast.
If you like sci-fi and horror stories, we invite you to read our free comics on Webtoon. Ghost Metal is a series of 100 original stories that you should definitely read with the lights on. Thanks for listening, and we'll see you
Next time.
next time.